Good evening, ladies and gentlemen.
Good evening, Prof.
Good evening, Prof, sir.
Good evening, sir.
Good evening. I am happy that I didn't tell you who to come physically today. I might not have been present. I am feeling one kind. But let the paper presenters present their paper, and then we'll discuss it next week. We are not in too much of a hurry. I'm not feeling too fine. But let the paper presenter present their paper, and maybe we take comments within, say, the next hour. Then we can go next week. We'll discuss the paper and then possibly switching to the next paper if possible.
Sorry about your health, sir.
Are the presenters here?
Yes, sir.
Sorry about that, Prof.
Yes, sir.
Yes, you are presenting law and language. Is that not so? You are presenting law and language. So, are you all present?
Yes, sir.
Yes, sir.
Yes, sir.
Is present, sir.
Yes, sir.
We can hear you.
I have your paper here.
We can hear you, sir.
I can hear you now. Can you hear me now?
Yes, sir.
Sir, we can hear you. We can hear you, sir.
Okay, I am using my phone and at a distant place from where I was talking before. So, 5 people were assigned to this paper.
Yes, sir.
Chidima. Isaiah, Judith, Chidima.
Yes,
present.
sir. Yes, sir. Yes, sir. Present.
Flag captain, please take note.
Present, sir.
Emmanuel Etatuvi.
Present, sir.
Ezine Onomajuru. Ezine Onumajuru.
You guys should go on now.
She's there. She's there. She's the one presenting now. She's there. Please.
She's here.
I'm here. No, it's Genevieve that is presenting. Genevieve.
Okay. Sorry.
Four.
Please, listen to your name carefully, please, sir.
I'm here, sir. Present, sir.
And then 5, Sule Aladi Genevieve.
Present, sir.
Okay. So all 5 are present. So how do you intend to present your paper? How many of you are presenting? Okay, so let's hear you. To give you 30 or 45 minutes to present.
Okay, sir. Okay. Good evening, sir. Good evening, everyone. I'm Sule Aladi Genevieve. Presenting on behalf of Group 5, and our topic is language of law. The context of our topic of our paper include introduction, historical perspective, nature of the language of law, language and legal interpretations, merits and demerits of simplifying legal language, remarkable developments and current trends, and then chapter 7 talked about conclusion and recommendation. By abstract, we stated the language is important in the legal profession, serving as the primary tool for communication, interpretation, and expression of legal concepts. In the legal profession, language is the vehicle through which laws are expressed, arguments are crafted, and legal concepts find their form. Lawyers navigate the nouns terrain of legal text, employing language as a tool for interpretation, persuasion, and advocacy. This research work seeks to examine the nature and scope of the language of law. It explores how language can be used to reinforce or challenge legal authorities, make an investigation into the reform of legal language, and the implication of understanding the language of law. In the first and second part of this paper, we shall examine the origin and language of the language of law. In the fourth part, we shall consider language and legal interpretation. In the fifth part, we shall look into merit and demerit of simplifying legal language. In the sixth part, we shall discuss remarkable developments from current trends and legal discourse, and further discuss landmark cases where language interpretation played a crucial role in a various legal language form. Our keywords include legal language, jurisprudence, interpretation, application, rule of law, access to justice. So, chapter 1. By introduction, we stated that the use of language is crucial to any legal system, not only in the same way that it is crucial to politics in general, but also in two special respects. Landmakers characteristically characteristically use language to make laws, and law must provide for the authoritative resolution of disputes over the effect of that use of language. Political philosophers are not generally preoccupied with questions in the philosophy of language, but legal philosophers are political philosophers with a specification that gives language and philosophy of language a special importance. We also stated that philosophy of law can gain from a good philosophical account of the meaning and use of language, and from a good philosophical account of the institutionalized resolution of disputes over language. Philosophy of language can also gain from studying the stress testing of language in legal regulation and dispute resolutions. In addition to their interest in the use of language in law, philosophers of law have developed a second interrelated interest in using insights from the philosophy of language to address problems of nature of law. This article outlines some problems in each of these two areas. After a brief historical note on the linguistic preoccupation of legal language. The only tool a lawyer has is words. Doctors, engineers, architects, and other professionals can make use of the latest technical development to help them in their work, but lawyers are basically left with the same tools they had when the profession began, which is words. Words are essentially tools of the law. In the study of law, language has great importance. Cases turn on the meaning that judges ascribe to words, and lawyers must use the right words to effectuate the wishes of their clients. It has been said that one will be learning a new language when you study law, but if actually a bit more complicated. There are at least four ways in which one can encounter the vocabulary of law. The first ways include field dimension or subject matter dimension of legal register, which provides for its separate terminology. Mode dimension of legal register requires highly formalized expression in the form of enactment, application, form, and judgment. Thirdly, under role dimension of the law register deals with machine translation and official use are included. Fourthly, the formation dimension of the legal register deals with legislators, judges and lawyers and litigants, judges and litigants, teachers and students of law. One of the great paradox about the legal profession is that lawyers are, on one hand, among the most eloquent users of the English language, while on the other hand, they are perhaps its most notorious abusers. In chapter 2, we talked about the historical perspective of the language of law. The philosophical connection of language and the law can be traced to Jeremy Bentham and utilitarian theory of law. His theory of utilitarian was supported by the empiricist theory of meaning of words, which he also developed. His history of legal positivism was based on meaning and words and the use of words. This was in contrast with the position of natural law theorists, who expresses the view that human beings are entitled to certain morals, rights and duties, regardless of whether or not it is enforced. To the proponents of natural school of law, language merely serves as a communication tool and plays no major role in explaining the nature of law or influencing the role of law. On the other hand, Bentham used linguistic acts to explain law as an empirical phenomenon. According to Bentham, the meaning of a word extends beyond its casual sense to its ability to serve as an imagery or substances or emotions, words, and they are incapable of such perception and meaningless. Language is therefore an innovation tools in law used to express the will of the sovereign in human community. Based on this perception, he also defined law as a group of signs expressing conceived violation or adopted by sovereign. The proposed violation or compliance with the assembled signs is act by a motive or pain or pleasure from the sovereign. Bentham's theory established a link between philosophy of law and philosophy of language. The link exists in terms of methodology of the law, which has direct connection to language, and the linguistic definition of which also applies in law. Several contemporary language philosophies are deeply rooted in Bentham's theory of meaning and use of words, including Frege and Wittgenstein context principles. Some views of logical positivists are the development of speech act theory. We also stated that in the 19th century, Hart built on Bentham's theory by using philosophy of language to describe nature of law. In 1961, Hart wrote the book The Concept of Law, where, based on the work of other philosophers, he adopted an innovation approach in explaining the use of language in law, and his work formed the origin of perception of law as a normative study. As the work or art of art was further developed by the 20th century, the use of philosophy of language is in the philosophy of law had become a jurisprudential discourse. Various theories which evolved in the process include Jarzembowski's theory of semantic conception of legal norm and theory of law as a language and as legal science. The 20th century was an era of various views and erosion which debunked the traditional perception of law. The Scandinavian legal realism school later emerged. The school developed the study of empirical language sensibility of law and evolved the position that therefore expression relation to a person's rights, duties, and obligations are incapable of being true or false. Rather, they are merely tools for taking advantage of philosophical conditions. So we further proceeded to the history and development of language of law. The language of law has a rich history that can be traced back to ancient civilization and has evolved over centuries. The language of English law, for instance, was influenced by Anglo-Saxon, Danes, and Normans, all of whom settled in England at various times. European legal language was heavily influenced by Roman law, even in countries that were mere occupied by the Romans. In contrast, although the England was ruled by Rome for several centuries, Roman law has had little influence there. The two most widely dispersed legal traditions around the world are the civil law system that arose in Europe and the common law that developed in England. The civil law gradually spread not only throughout of Europe but also to former European colonies in Africa, Asia, and the Americas. Following similar routes, the common law stretches across much of the globe, from England to North America to African countries like Nigeria and finally to India. The development of civil law in Western Europe is deeply rooted in Romance law, which persisted beyond the fall of Roman Empire. Unlike legal system of ancient civilization such as the Egyptians and Mesopotamians, Roman law endured due to its writing, procedural rules, and systematic category of legal concepts. Key to its persistence were jurists, affluent individuals who studied and offered legal opinions. This durability is evident in the lasting influence of Roman law on modern legal system, with remnants persisting through the centuries. In the 4th century, the Roman Empire split into the Western and Byzantine Empire. The Western Roman Empire declined, leading to small states governed by the customary law, the fragment of Roman law surviving. In contrast, the Byzantine Empire, especially under Emperor Justinian, endured for a millennium to revive Rome's glory. Justinian tasked scholars with creating a systematic body of law, resulting to a corpus juris civil. This compilation, often called the body of civil law, exemplifies the exemplifies during impact of the Roman legal tradition. In the latter half of the 11th century, the discovery of manuscripts containing Justinian corpus juris civil is a Pisa led to significant development. Legal scholars in Bologna, studying and producing editions with commentaries, became known as glossator. Bologna University attracted students from across Europe eager to study the Roman law. This education contributed to the founding of other universities where Rome law became a prominent subject. The study of Rome law became crucial for judges, leading to legal training requirements centered around the corpus juris. Consequently, civil law countries in Europe share a common legal heritage, originating in Rome, systematized in Byzantium, ready discovered and developed in northern Italy, and spreading across the continent. This shared heritage has resulted to common legal concepts and a language influenced by a Latin terminology of the corpus juris, creating a situation where European lawyers effectively speak the same conceptual language. Historical evolution of legal system. Latin, originating from Roman law, has endured as a language for labeling key legal concepts. The corpus juris is influential in areas like contracts and torts, constitute a part of jus commune or common law across Europe, complemented by canon, customary, feudal and commercial laws. Despite the nomenclature similarity, the common law of England had a distinct history, initially contributing to a unified European legal culture before experiencing a shift towards nationalism. The shift emphasized indigenous or customary law, leading to the application of local laws in courts and the written documentation of oral customs in the vernacular. In the 18th century, the Enlightenment prompted re-evaluation, and English lawyer Jeremy Bentham advocated legal reforms through codifying, aiming and systematizing and publishing laws into statutory forms. Around 600 AD, Christian missionaries arriving in England brought religion, literally, and the Latin language. This led to the emergence of the first written English laws, which, with the Anglo-Saxon king issuing codes often in Latin or Old English. The Norman conquest is 1066 marked a significant shift, ceasing the use of English as a written legal language. The rulers, now French-speaking, conducted legal transactions in Latin. By the 13th century, Latin statutes became common, royal courts were established, and professionals class of lawyers emerged. French remained the language for oral proceedings until around 1300, persisting in writing statutes until the late 15th century when English replaced it. The continued use of French in the legal profession faced criticism from the public, with accusation of concealing of law for monopoly preservations. Lawyers defended law lawyers defended law French, citing its precision concerns arose that expressing the law in English might prompt individuals to act as their own lawyers without understanding, leading to potential harm in without understanding and leading to potential harm. In response, the 1362 statute mandated court pleadings in English for better self-governance. Although Parliament in 1650 required law book to be in English during the Commonwealth, the statute was repealed with the monarchy restoration. By 1731, law French and Latin were abolished in legal proceedings, requiring documents to be written in English. Literal translation were favoured, contributing to the persistence of technical legal terms. Now, we also stated some legal documents that shaped language norms. So in our paper, we mentioned that language in jurisprudence has been significantly shaped by historical cases and legal documents throughout the development of legal system. Several landmark cases and key legal texts have played pivotal roles in establishing and refining language norms in the field of law. We shall briefly explain the most important legal documents and contributed to the language of law. The Code of Hammurabi, proclaimed by Babylonian king Hammurabi Hammurabi during the reign from 1792 to 1750 BC represents one of the earliest and most comprehensive written legal codes. In his effort to consolidate power, Hammurabi expanded Babylon along the Euphrates River, uniting southern Mesopotamia. The code, consisting of 282 rules. First, first, he established standards for commerce and outlined fines and punishment to ensure justice. This code is significant for its role in shaping legal language and providing a basis for the concept of an eye for an eye. The clarity and specificity of language in Ama in Hammurabi Code set a precedent for legal writing, inscribed on the massive black stone stele, shaped like a finger. Hammurabi's code Hammurabi's code unfortunately fell prey to looting by invaders but was later rediscovered in 1901. Secondly, the Justinian Code of between 529 to 534 CE largely influenced subsequent legal systems in Europe, serving as foundation for many modern legal concepts. The precision and organization of language in Justinian Code contributed to the development of legal terminology. Upon ascending to the throne, Justinian promptly established a commission tasked with addressing imperial constitutions. The 10 commissioners meticulously examined existing copies, identifying practical value, removing superfluous content, resolving contradictions, and adapting previous provisions to the contemporary context of Justinian reign. This resulted in Codex Constitutionum, which was officially promulgated in the 529 CE, rendering all non-included imperial ordinance obsolete. Although the original code is lost, a revised edition from 554 CE persists within the Corpus Juris Civil, and this was buoyed by the success. Justinian embarked on a more complex mission of streamlining jurist writings. In 530 CE, a new commission of 16 eminent lawyers set about this task of compiling, clarifying, and ordering. The outcome, published in 533 and was 50 books, which became known as the Digest or Pandex. Thirdly, another instrument worthy of note is the Magna Carta of 1215. Why not a comprehensive legal code? It introduced key concepts.
Hello?
Hello,
Have you
can
finished?
we hear me? Okay.
Yes,
No,
yes.
sir. So chapter 3, we talked about the nature of language of law, and we stated that the legal language or the legal English take into its fold its use in the context of legal documents, contracts, licenses, court pleadings, summons, brief, judgment, etc., laws, acts of parliament and subordinate legislation, case reports, and legal correspondence. We also stated that national constitutions have come into existence by means of written language. Laws and statutes are enacted and laws and statutes are enacted and contractual agreements between private and individual which takes effect. We also stated that there are different types of legal writing and also all of them can be grouped together in a legal language. Though they differ, the differences do exist. And as discussed, the following are the kinds of legal writing. The number one, we have the academic legal writing as in law journals. We have the judicial legal writing as in court judgment, and we also have the legislative legal writing as in laws, regulations, contracts, and treaty. So we also further mentioned and explained what the word law is. In our seminal paper, we stated that it is undeniable that medieval jurists have sought a voice that would differentiate Roman from the new customary law, which prevailed in Europe towards the Middle Ages. And we also stated that this can be differentiated from other types of rules, and this include legal rules which are obligatory. In legal rules, the citizen has no choice but to obey them. We also have legal rules that are created by formal and unusually somewhat complication and solemn procedure. We also mentioned that disputes concerning their complicability or their breach, breaking of laws are subject to special procedures which might involve trials in the court. Their mechanism is a regular machinery which exists for the enforcement of law. So we also stated so let me just go straight to chapter 4. In chapter 4, we talked about language and legal interpretation, and by that we stated the meaning of language by saying that language is very important, and the whole essence of language is for it to be meaningful. The study of human language is multifarious and complex, but the study of meaning is one of the most complex aspects. In order for language to be able to be communicated effectively, it must be able to convey the meaning the intended which is intended by the speaker to the listener. Study of meaning relates with study of linguistic structure, including the study of semantics, lexical meaning, and conceptualization. This will also include lexical semantics, which is the study of idiomatic expression used in conveying ideas in each language. Compositional semantics, which relates to various parts of sentences and how they are integrated to convey meaning, and assessment of relationship between contextual meaning and speaker intention. We also explain language, thought, and communication. And we stated that there are various theories of language, thought, and communication proposed by different philosophers from various perspectives. In one perception of language and thought, it is that language is used primarily in thought. Thus, all or most human thoughts are in mother tongue or natural language. In most or all communication, a speaker communicates their thoughts in the language they use in thinking. Basically, linguistic communication involves communication of propositional content. The, pro- the proponent of use of language as a thinking tool further posits that natural language may be used as code, requiring listener to decode such communication. One might use natural language as a code as well, but the implication being that when a person learns a second language, the mother tongue become a code for decoding the second language. Since the person thinks in the mother tongue, this may go on until the use of this may go on until the use of the second language is perfected to be used smoothly in thought and communication, which communication with other speakers of language. Therefore, in the absence of language expression, in this absence of language expression of thought and other prepositional attitude will be impossible. Therefore, when a child learns first language, the language is more than just a code. Rather, it constitutes a system by which the child makes representation of his thoughts. We also explained what language and communication is, and we stated that one of the major proponents of of the theory that language is used primarily for communication is J.J. Katz, who posits that natural languages are instruments for communication involving transmission of meaningful language from one speaker to another using syntactical structure objects and acoustically realized objects. We also explain what language, English language, and vagueness is. So we stated that language is the basis of humanity. It is the basic tools by which man thinks, communicates, interact, transact, businesses, and dream. Therefore, all human society and indeed the globe, the global community has continued to exist because of man's ability to maximize the use of language. Yet, fully understanding of language is yet to be grasped by man. We also explain the function of vague language. To the language expert, linguistic vagueness does not entirely exist in vacuum, as it's been found to be capable of serving two major communication functions. Language vagueness can serve the purpose of interaction, to give the exact amount of information which the speaker intended without overburdening the listener with unnecessary explanation or details. Now, the challenges of linguistic vagueness for non-native speaker is that there are several words, expression, dictum in English that are outrightly vague and difficult to give precise meaning. So in our chapter 5, in
I've spent
in
more than
it's
45 minutes.
okay, let me just quickly go to our conclusion because we still have a lot on our paper. So by our conclusion, we stated that as we come to the end
Talk about
of this sem-
simply justify or argue against simplification and discuss the plain language movement.
sorry, sir, I can't hear you.
Justify
Hello?
or argue against simplification of legal language. Then talk about the plain language movement. I've seen where you discuss that. Let's hear what you said. Do you understand?
No, sir.
The aspect of your something when you talk about merit and the merit of simplifying legal language. Let's hear you.
Okay,
And then the
okay.
plain language movement. Quick.
Okay.
Or did somebody else present that part?
Okay, Emmanuel, please, can you take that part?
Hello?
Hello, go on.
Which part, please come again, which part?
35. 35.
Hello.
On page 34.
Hello, Prof. I will take
Yes.
it. That's
You will-
5.0. Anya
Yeah,
Unjide.
from place 34.
Okay. Yeah, go on.
Merits and demerits of simplifying legal language. Yeah, we talked about the plain language movement. Under the introduction, we said most scholars have propounded the need to simplify the legal language in a bid to make it render the law intelligible to non-lawyers. Using the law effectively requires expertise that goes beyond far understanding and the meaning of the use of words used to communicate it. Certain complex aspects of the law cannot be eliminated by mere simplification of language. Simply put, law exists solely in and through language. Legal language is usually perceived with negative connotations because it appears specialized, elevated, and technical, especially in its written form. Most legal languages from colonized countries are an offshoot of their colonial masters. Although complaints about legal English go back several centuries, it is generally agreed that it was not only until after World War II that we can speak of the beginnings of a movement which would coalesce in the United States in the 1960s, thanks to the influence of seminal works such as those of Melinkoff in 1963. Here, we're just talking about that the first propounder of simplifying legal language was Melinkoff in 1963 in his book, The Language of the Law. Here, there were technicalities about the use of language by lawyers. Some persons were saying that law language is vague, that it is unintelligible to non-lawyers, that in terms of communication, they tend not to understand ordinary persons tend not to understand what lawyers say because of the terminologies being used in law. The former has to, okay. The focus of each of these two writers highlights two of the strands that have been the principal concern of plain language exponents in the legal sphere ever since. On the other hand, modernizing the language of the law, making official communication clearer and more effective. That's Melinkoff was of the opinion that the legal language should be made plain for everybody, even for the layman to understand, so that it will be clearer for understanding. The two areas, although clearly interrelated, require different sets of skills and priorities. The former has to do above all with the way legally binding texts are drafted by removing those elements of legalese, whereas the latter has to do with how organization, generally station, communicates with the public by removing those elements of obscure legalese. Now, in Nigeria, a country characterized by its rich linguistic diversity, that's earlier in 2016, the prominence of English in legal processes presents both opportunities and challenges. The Nigerian legal system, heavily influenced by British colonial heritage, relies on English for legislative drafting, judicial proceedings, legal education, and legal communication. This reliance on a single language in a multilingual society raises critical questions about accessibility, comprehension, and the equitable administration of justice. The significance of language in the legal context cannot be overstated. Effective communication of laws ensures that citizens understand their rights and obligations, while precise legal drafting prevents ambiguities that could lead to misinterpretation. Here, the paper is just talking about that Nigeria, that we have diverse languages. That's all, we have several languages that were not just dependent on English, although we got English based from our colonial masters. Moreover, the enforcement and interpretation of laws demand the clear and the consistent use of language. There are merits of simplifying legal language Hello, Prof. Merits of
Yes,
simplifying legal language, efficiency. Then, under the plain language movement, advocates for the simplification of legal language using clearer words, structure, and design to make it more understandable and accessible to the general public. Plain language refers to the use of common words and clear expressions that can be easily understood by readers on their initial reading. One of the merits we talk about efficiency, that's it is easier to read and understand for both lawyers and non-lawyers. That's when you remove the legalese from the legal language, it is more easier for non-lawyers to be able to understand. Disclosing errors. Simplified legal language helps expose errors. In contrast, legalese tends to hide inconsistency and ambiguities because of the words being used. Because errors are harder to find in dense, convoluted prose. Then, image of the legal profession. Simplified legal language enhances the image of the legal profession. The obscurity of those traditional language has long since been a source of ridicule. And quite apart from its obscurity, legal writing is impersonal. It creates barriers of aloofness. Then we talk about accessibility and equality. Sorry, on that, okay. Yeah. Sorry, on that, the image of the legal profession, we also talked about the surveys in the United States and Canada disclose that readers find language seriously incomprehensible, legal language seriously incomprehensible, and find legal documents very difficult to read and understand. Then we now talked about there's also the Plain Language Institute of British Columbia and also their preliminary reports. Accessibility, in that merits, we talked about the accessibility and equality. By using plain language, legal language becomes more accessible to individuals without a legal background. This helps reduce the access gap to legal information and enhances and ensures that everyone has an equal opportunity to understand and engage in the legal process. We talked about transparency and readability. That's another advantage. Using plain language in legal documents improves clarity and comprehension. It is clearer and easily understood. Individuals can better understand their rights and obligations, and also the implications of the legal documents they encounter. Reduce errors and non-compliance. We also talked about it also saves, it's cost-effective and is efficient. Then we now talked about the demerits of simplifying legal language. Then Francis Benyon in 2007 clearly states that the plain language movement has faced failures, and he sees issues in the fact that plain language campaigners do not treat law as an area of expertise. That's according to Francis Benyon. After distinguishing 4 aspects of legal text from a text which is law, texts about law directed to non-professionals, the author criticizes the plain language activists for their pursuit of self-explanatory legal texts, claiming that the law is made up of what I call law texts. That is, texts that actually are law. They constitute the law, which resides only in words. The purpose of a law text is geared to this function of instituting the law. It also said that many plain language campaigners fail to grasp this point. However, Francis Benyon insists that the cause of the miscomprehension of legal texts by laypersons lay in an inadequate composition of the old text and not in the use of technical terms. Technical terms ensure precision. That's one of the demerits. Legal language is complex because it aims to be extremely precise. Simplifying it can lead to the loss of specific meanings and nuances, which might result in misinterpretation. Jargon words and technical terms are a part of legal language. The language of professionals and their replacement with general terms raises doubts and inclines to the belief that such a substitution may affect the balance between simplicity and precision. Another demerit is legal language is complex in content. Complex ideas often require complex language and many times cannot be expressed in plain language. Judicially defined list of the meanings that are attached to certain words and phrases most times lose its meaning when simplified. Rephrasing them may shift their meaning, which would have to be newly established. Many authorities do not accept the idea of simplifying legal language. Every word in a status is intended to have a definite purpose, and no unnecessary words are intentionally used. Anyone who wishes to understand a statute must be willing to spend a little time with it, reading it through slowly and carefully from beginning to end, and then rereading it several times. An ordinary reader must simply accept the fact that he will not be able to grasp the full implications of a bill, as it is a serious document meant to be precise, not to be read like the morning newspaper. Words are the principal tools of lawyers and judges, whether we like it or not. They are to us what the scalpel and insulin are to the doctor. This statement shows Newman's belief that the form of legal language is a delicate matter and it is a balance not to be disturbed. Then we'll now talk about the remarkable developments from current trends. Talked about that the plain language.
You should conclude now. What was your recommendation? What did you recommend?
Okay, under our recommendation.
Okay, let me take over from.
Okay, can continue.
Thank
Genevieve.
you, Judy. Thank you. Yeah, no, it's Ezine. Good evening,
okay,
sir.
Ezine.
Thank you so much. So let me just highlight our recommendations and cite examples as to where certain changes have been made. So prior to now, because in language and English generally, that is Nigerian spoken word or spoken language. The majority language that we use to communicate to one another is English. It is our legal franca. So there has been some level of simplicity, coming from the vagueness, coming from all the verbosity of the legal language. We've been able to simplify our language to make sure that it is easily understandable or understood and communicated from one person to another person, from the court to the judges, from the court to the lawyers, and to clients and all that. So prior to now, we used to have things like or words like heretofore, herein after, pursuant to, and because they have been simplified, we see words now, or some of our judgments carries words like before, below, under, despite, because we are trying to simplify it in such a way that it is easily communicated. The message is not lost in the process. So we are saying that we are urging all policymakers, judges, professors, lecturers, students, legal practitioners to adopt a plain language for easy communication, to avoid jargons, verbosity, to make the whatever we are saying clear and concise as possible. We are streamlining, we are eliminating legal technicalities, and abolishing unwarranted injunctions and frequent adjournments, because in trying to understand the points or the processes presented in court, the judges would say, okay, move, adjourn to a new date, all these things. We are asking that plain, simple languages be used, and we are also stating that we know lawyers find this some sort of it's a bragging right, to use certain legal terminologies, because we don't want to make it a layman's language in one way or the other. But we cannot keep holding ourselves back in the 19th and 16th century as we used to. So we need, in order to make these changes, we have to undergo mandatory training and capacity building. This is to make sure to enable lawyers and judges know that no matter how simple your words are, it still carries the power, it still carries the weight, it still carries the effect that you want it to carry. We are saying that national public awareness campaigns should be made, robust monitoring and evaluation framework to ensure that communications and conversations are passed on simplicity, without any form of confusion, verbosity, and all that. So our call to action is that we are urging all stakeholders, I mean you and I, to join in this crusade for justice, from. Together, we can make a difference and create a better and brighter future for Nigeria. Thank you, sir.
Thank you very much. Before I go, do you have any comment or do we go to the next thing? There is something that I think is better to paper. There is nowhere where you discuss nature of the language itself. When you were concluding now, you talked about use of certain jargons and all of that. People who present this topic, you highlight
Hello.
Hello, Prof. I can't hear you.
You're muted, sir.
Yeah, let's go. Come on.
Hello, sir. We
I'm
couldn't hear
saying
you.
that I'm saying that you people didn't specifically discuss the nature of legal language, where you be talking about all this verbosity, all these use of words that convey the same meaning, and yes, you talk about jargons and all of that, but you didn't discuss that under this. Okay, well, there's a nature of legal language here, but
Yes, it is.
it's
Okay.
not the usual. It's not the usual thing we normally hear there. Like all those things you are saying that you are recommending that we should do away with. I believe there ought to be somewhere in your seminar paper where you discuss those things. What is it about legal language that makes it difficult for non-lawyers to understand? Do you understand? All of those things. But it's all right. We will discuss next week. We'll discuss. Hello?
Okay. Sorry, sir. I wanted to point you to page 27 where we talked about ambiguity, incoherence, incompleteness, concerning the nature. Yes, sir.
That's what I want to hear. So you discuss
Yes,
it
sir.
somewhere.
Yes, sir. It's in page 25 to 27. And then we also mentioned the canons of interpretation, where we have the literal rule, the golden rule, the mischief rule. So yes, sir. That's from page, I think 27 again to page 30. Yes, sir. Then we also talk about doctrine
Okay,
of
I
stare
can see.
decisis, argument of
From page
analogy.
25, you talk about
Yes.
ambiguity, contestability,
Yes,
coherence,
sir. Yes, sir.
indeterminacy. Okay.
Yes, sir.
Okay, we'll go over your
vagueness.
paper.
Yeah. Thank you,
Let
sir.
everybody go over this paper. Let everybody go over it and let us discuss it next week. I'm sorry.
It's okay, sir.
I'm not. I think I've done too much work for my strength today already. So let's divide the discussion till next week. But let all of us read them, please.
All right, sir.
Let us all of them read what they have said.
Sir.
Okay.
Thank you, sir.
Thank you, sir.
So I see you next week.
All right, sir.
Okay, sir. Thank you,
Get
sir.
well soon, sir.
Thank you, sir.
Yeah, thank you, sir. Thank you, sir.
Please, can we confirm that next week class is also virtual class?
You should decide what you want. You should decide what you want. I'm
Virtual
okay
class,
with
sir.
We
anyone.
want virtual
Virtual
class,
class
sir.
is better. I'll communicate back to Prof now.
Okay.
Our class rep will do that.
Sir,
Okay.
we'll pass the information to on the group chat. Thank you, sir.
Thank you, sir.
Thank
Sir.
you.
Get well soon, sir. Bye-bye, sir.
Okay.